Well, the sobriety court really sort of picks up, I think, where the super drunk law left off. And what I mean by that is we just talked about super drunk only applies to first-time offenders. What I haven't told you is that there's a driver's license sanction that, again, is very much of an enhanced driver's license sanction, and again, it falls between the first offense and the second offense.
So that's for the super drunk?
For the super drunk.
And what is that enhanced?
For the super drunk law, instead of a 180-day suspension, 150 days of which is restricted for a first offense, it's a 1-year suspension with no driving at all for the first 45. The remaining 320 days is on an ignition interlock device, and it's a restricted driver's license. If it's a second offense, it's an absolute revocation for a year. So again, it sort of fits between the two different types of offenses. The reason that's significant is because the sobriety court law, as I said, it sort of picks up where the super drunk law left off. For second offenders, which the super drunk law doesn't apply to at all, for second or subsequent offenses, if the license is revoked, the sobriety court allows the offender the opportunity to get their license back. If that happens, it's 45 days without a license, followed by 320 days of restricted driving privileges with an ignition interlock device. It's exactly the same as the super drunk. The difference is that for the sobriety court law, the court is actually monitoring and overseeing the license process, whereas with the super drunk law, it's done by the Secretary of State and it's done automatically. With sobriety court, the court itself, the court within which the offense occurred, the sentencing judge, has to monitor the offender and report back to Lansing that the person is satisfactorily completing the sobriety court. If they're not, they don't get a license.
I know every community is different. The sobriety court, that's part of the law that took effect last year. And how widely is sobriety court actually coming into being?
I think the legislative intent was to encourage sobriety courts, and in general, I think sobriety courts put the emphasis in the right place, meaning it puts the emphasis on sobriety and on rehabilitation rather than punishment. The problem is partly funding and partly personality, I think, of the various judges. Some judges don't really have an interest in being what is effectively a social worker, because the sobriety court requires the judge to sit on the bench, not in an adversarial, the judge is never in an adversarial position as such, but what's happening in the courtroom is not adversarial. The judge is just sitting there assisting what is really almost like a group recovery meeting.
Well, that's interesting. Judge Sosnick and some other judges in Oakland County have been doing a drug court, and that sounds a lot like the sobriety court, and they're saying it has a phenomenal track record, and they're big believers in it.
It is, and if Sosnick was still at the 48th District Court, more than likely he would run a sobriety court, because that's where his mind is at.
I would bet on it.
Other types of judges, for whatever reason, they don't want to do that, or maybe they don't believe in it. But the statistics, from what I understand, and I haven't scrutinized them, but from what I understand, the repeat behavior or the recidivism of drunk drivers that have been involved in sobriety court is far lower than those that have not been involved with it. So it appears that, again, it provides or protects the societal interest of making sure that people don't reoffend.
Can you name a few communities that do have sobriety courts in this area?
The sobriety court is common actually in Ann Arbor, for example. There are several judges in Ann Arbor that
wouldn't
have
surprise me either.
Traditionally had sobriety courts. There is a judge in the Rochester District Court that has a sobriety court. In Clarkston, they've had a sobriety court for many, many years, and they have really done a nice job with it. So it really depends on the judge. Oh, by the way, the 51st District Court probably has the most, I'm not sure what the word is, the most intact or the most functioning sobriety court. They really emphasize it there.
That's one in Clarkston or Waterford?
The one in Waterford.
The one in Waterford. And are there statistics to compare the difference between those courts who have them and those who don't?
There are, and those are kept at the federal level. I don't have the statistics available, so I can't recite them for you or for the viewers. But the statistics that I'm aware of do show that there is less repeat behavior for people that have been involved in sobriety court.
But it also sounds like, from your perspective as a defense attorney, if there's a jurisdiction in the Office of Sobriety Court, it gives you another avenue, another outlet, something that you can do for your client that you can't do in a jurisdiction that doesn't have it.
That's absolutely true, and it's one of the problems that we have when we have an offender in court A that doesn't have a sobriety court and an offender in court B that does have a sobriety court. Even though the offense might be exactly the same, their background may be exactly the same, I can't get them the same result unless they have a sobriety court. Now, there are some drawbacks to a sobriety court, especially from a defense attorney's
What are they?
perspective. Generally speaking, because, as I said, it's sort of a non-adversarial position, the emphasis is on getting the person to plead guilty as soon as possible and get them into the sobriety court, which takes away from me the ability to, what I think to be appropriately defend the case, what I would refer to as get due process for my client. That's the drawback. The best sobriety courts are the ones that emphasize the sobriety court on the front end, but if you step back and let the judge know, wait a minute, I want to look at the discovery, I want to at least see and explore the opportunity for a defense before we make that decision. In the best sobriety courts, they're fine with that. There are some sobriety courts, like the one up in the 86th District Court, which is Traverse City, where if you want to defend the case, sobriety court's not available, and that's where I think there's a problem.
So what you're saying, you could put someone into the sobriety court, review all options, go through discovery, and then tell your client, look I really think the best thing is to work out a plea. So continuing along these lines, we'll have the plea. On the other hand, if you feel there are some flaws from the prosecutor's standpoint, you can have someone in the sobriety court and, I guess, change horses midstream, so to speak.
Right. Well, actually, the sobriety court's only available for people who have been convicted. So it's a post-conviction remedy,
okay.
if you want to call it. It's part of a sentence. Now, and you kind of put your finger on one of the issues that a court may have with this, which is what happens while they're on bond. How do I, as the judge, monitor them appropriately to make sure that they're not going to reoffend? They think the best way to do that is sobriety court. I would say, let's put them on significant bond restrictions if that's what you want to do. We can even mimic sobriety court, but give me the opportunity to defend the case and make the right decision.
Will judges do that?
Most of them will, but not all.
What about in this district, in the 48th?
The 48th District Court, to my knowledge, at this time does not have a sobriety court available.
Well, it sounds to me that, in many respects it's an illness and you should treat it like that, and that's why the idea of the sobriety court sounds like a great idea.
Exactly, and that's why I said in most instances I think sobriety court puts the emphasis in the right place, which is on recovery.